All right. Thanks for being here today, especially on this most important first day of March Madness. We're doing this a little bit before the games begin, so that's good. If you have questions during the presentation, you can use the comments area in the stream, and we will see them, and we will do our best to answer them as they come in. After the presentation, we will distribute the slides and a fully written out version of this presentation to your email. We plan to do more of these types of presentations regularly on topical topics as we see them and they're appropriate for us to present on. Now I'll present Scott Crook, the managing partner of Crook Legal Group. He will start us off, and we will go from there.
Thanks, James. It's good to be here this morning. And as you can see on your screen, Anna Briner joins me, and we'll be presenting to you today about this important issues involving potential ICE audits and raids. So a little bit of an introduction of the firm as we begin. Crook Legal Group has been around for over a decade. I've been practicing for almost 30 years now and have been practicing in the area of employment. We provide at Crook Legal Group several different services. We provide preventative services and provide advisory services to our clients. We consult with them on employment law and HR best practices, and we review HR policies and develop contracts, etc. And as you can see on the screen in front of you, we also do litigations and representation in litigation and do training and support. And we're very proud of what we've done and what we do. We have a good employment law group. Carolyn Howe is also part of that group. She's not available today. She's out of town, but she's a very important part of our group as well. Turning now to the topic of the day, we're going to talk about audits and raids of the U.S. Immigration and Custom Enforcement. Before we get into a discussion, there is a difference between audits and raids, and we're going to focus. We're going to present on those two different topics, but to sort of give you a bit of a background about them, I think it's important to sort of outline the players from the administrative agencies that are involved. All of the agencies that are involved with audits and raids are found within the Department of Homeland Security, and there are essentially three different agencies. ICE is one of the agencies, and they deal with the enforcement of immigration laws within the interior of the United States. Of course, you've heard of Border Patrol, which is CBP. They are charged with the enforcement of the border and places that are essentially the equivalent of the border, such as ports of entry and stuff that may not be on the border. And then finally, there's the U.S. Citizenship and Immigration Services. And that agency generally deals with the process. They process and make determinations on citizenship status and those sorts of things. We are talking about today, essentially, what ICE is doing. And of course, as everybody knows, there's been a change of administration. The administration is very aggressive in enforcing immigration status, and that means there's an increase of audits and raids. And employers, of course, should follow immigration law, and they should do everything that they can to comply with the requirements of the law. And then having done so, though, they should do everything they can to reduce the risk from employee misbehavior, employee mistakes, or the dishonesty of employees. What that means is an employer can do everything that it can to make sure that it's complying, but they can have an employee who has every reason to not disclose that they're illegally in the United States, provide a false documentation. And the employer can be doing everything that it possibly can to prevent that from happening. And still there can be some violations. And so this presentation is about how to avoid the risk that employers face in audits and raids, and what it should do, what employers should do when they are faced with those possibilities of an audit and raid. It will happen almost every time. Almost every employer will at least be audited. It will happen at some point. And particularly in certain industries that are the focus of audits and raids. So today we're going to talk about those two separate things, what an audit is, what a raid is, what you can and cannot do with respect to them. And Anna Breiner will now be talking about audits.
Thanks, Scott. And good morning to everyone. As Scott mentioned, I'm Anna Breiner. I'm an associate attorney at the firm, and I'm going to jump into the audit part. So the most common ICE audit is the Form I-9 audit. This is going to look at your compliance with I-9 forms and their supporting documentation. What typically happens is ICE is going to serve you with a notice of inspection, and then you'll have at least 3 business days to provide ICE with the requested documents. We recommend you don't provide them early. You're going to want to take your time to really make sure that everything is highly accurate, because you can incur fines if there are violations, even if they're accidental. So be really careful with it. As far as employer responsibilities during an ICE audit, number one, when an audit is being conducted, remember you don't need to allow ICE agents to non-public areas of the business. So unless they have a judicial warrant, they don't have any authority to go there. So you don't need to let them in to those areas. You should also contact legal counsel immediately if ICE arrives. You don't need to answer their questions or sign their documents until you've been able to consult with an attorney. And then if your employees are unionized, you're going to want to notify the union. Make sure you're keeping copies of everything that ICE requests and other important notes that you can provide to the union as well as to your employees. So what kind of documentation is ICE going to be looking for? Typically, they'll start with the I-9s, the obvious one. So you'll want to make sure that you're prepared with those, that they're updated, and it's not just current employees, but also recently terminated employees who may be subject to the audit. So you'll want to make sure you're keeping their records as well. You'll want lists of current and recently terminated employees, the payroll records. You may need E-Verify records and the audit trail there. And then you'll also need business ownership information, such as the articles of incorporation, business licenses, and other relevant documentation. So it's the I-9 as well as the documents that support information about your business and support the I-9. So after ICE collects this information, what do you do? So mostly you're going to have to wait at first. ICE is going to review everything that's been submitted. This can take a while, especially depending on how many I-9s they choose to look through and how much they collect from you. But when they're done, they're going to either issue a compliance letter saying that they didn't find any violations, or they may issue a notice of suspect documents. If that's what you receive, it means that ICE has determined that one or more of your employees does not have proper work authorization. And so you'll then have 10 days to either provide the work authorization or to terminate employment. And as an employer, you should definitely notify the employees in question if you receive this kind of documentation about them. And it's important to understand there are really serious penalties in some cases for Form I-9 violations. You may just get a warning, but you could also incur civil or criminal penalties. And there are a lot of monetary fines for substantive errors in your forms or failure to comply procedurally. So you're going to want to be as accurate as possible and try to get these documents in order ahead of time so that if an audit occurs, you're ready to go. And I think
all right.
raids, yeah.
All right. So now we look at raids. I think it's important to understand, and we can talk a little bit about the difference between what an audit is and a raid is. So an audit is something that you would ordinarily expect as an employer, just as a regular check on whether you're complying with the immigration requirements. So are you following verification techniques? Do you have all of your documents in order? And those sorts of things. You're required by law to keep those documents and keep particular documents. And therefore, an audit is essentially something that you would expect to have to comply with. Now, and I think it's important to note, and this is important with respect to raids as well, is that audit everything that an employer let me say it this way: ICE is subject to the Fourth Amendment. So that means that it cannot conduct unreasonable searches and seizures on any private entity. And so even with an audit, an employer can refuse to consent to reply to the audit without a subpoena or warrant being issued. That's not our recommendation. Our recommendation is to cooperate if you can with audits, but that cooperation should be careful cooperation, and you should have the time that you need to respond. In audits generally, since COVID, most of the time an audit will be people won't just show up at your workplace and say, okay, we're going to conduct an audit today. Now, sometimes they will do that. If they do that, and we're talking about an audit here, you have the right as an employer to say, well, wait, we have an attorney. We want to talk to the attorney first. We're happy to cooperate with you, but we want to talk to our attorneys. A raid is different entirely. What a raid is intended to do is to typically, it's to go and detain undocumented employees. In other words, ICE is showing up not to find necessarily violations of the employer, but it's they're showing up to find undocumented workers at your workplace. And generally, a raid is going to occur without prior notice. So, whereas an audit, you're probably going to get some notice before people show up. A raid, they're just going to show up at your door. And it's important to know that when a raid is conducted, that employers have their constitutional rights and should exercise them. So in order to understand what authority the ICE will have when they come to do a raid is to understand what they have in their hand when they show up. So let's say that ICE shows up at your door and they say, oh, we're trying to find, John Smith. We think he's here illegally, and we want to find him. Ordinarily, under the Fourth Amendment, ICE can go into any public area to conduct a search. Now, you can also say to them, if they don't have a warrant, well, we don't want you we don't want you at the business, and so please leave. And if they don't have a warrant, they have to leave. They will sometimes show up with a warrant. And there are essentially two types of warrants you should expect when ICE shows up. One is an administrative warrant, and that will be in the materials that will be supplied. And this slide is a little blurry. There can be two types of warrants. There are two types of warrants: judicial warrant or an immigration warrant. Immigration warrant is going to be issued by an administrative law judge, and it's going to come from the Department of Homeland Security. Those warrants only allow the agency to seize a person. In other words, to find an illegal a person who may be undocumented, who is illegal, and take them into custody. That type of warrant only allows an administrative warrant only allows the seizure of a person, and it does not allow ICE to go into any non-public area of an employer. It only allows it to go into public areas, does not allow a search, and it only allows the agency in the public area to seize a person. These types of warrants are not, an employer does not actually have to comply with an administrative warrant unless there is a judicial determination from an actual district court that the warrant itself will be enforced. And so an employer can refuse to comply with an immigration warrant. A judicial warrant, on the other hand, will be issued by a district court. And a judicial warrant can order both a seizure, an arrest, or a search, and that search can include any can identify a non-public area. And so, if the ICE comes with a judicial warrant, an employer cannot resist that warrant. If it comes with an immigration warrant, it can. Whether it wants to or not is another question, but that's just for your information. Also, it's important to note the difference between a subpoena and a judicial subpoena and an immigration subpoena. A warrant authorizes searches and arrests. A subpoena is a court order requiring an employer to respond to certain requests, to provide documents, to provide, for instance, videos and that sort of thing. And it's similar. The issues with a subpoena are similar to those with a warrant. With an immigration subpoena, it has limited. An employer can resist an immigration subpoena where it cannot resist a judicial subpoena. When I say it cannot, I'm not saying that you cannot object to them. You could go to court with a judicial subpoena. You can do that also with a warrant and actually file a motion to quash the subpoena or the warrant. But you must comply with the warrant and later object if it's a judicial, if it's issued from a district court. So it's important to know the difference. So having described that, let's go to what you should do in preparing for a raid. First of all, employers should designate a point of contact to communicate with ICE agents. You should have identified, this is the person that we are going to give the responsibility to speak with any ICE agent that shows up. You should provide know your rights training to employees, emphasizing their right to remain silent, to speak to an attorney, to refuse to answer questions. And this is probably the most important thing to do, is to instruct employees who do not have general management authority that they should not consent to workplace entry unless it's legally required. So those employees should know, hey, if I don't have management authority, I need to send an ICE agent to the person who is the point of contact, who then can deal with whether we're going to allow somebody to come in. Because you can have an employee who does not have that authority say, oh yeah, you can come and look in our break room, even though that break room may not be a public area, and the ICE agents can say, well, you gave us consent. So you need to train your employees that they should not do that. That they should only allow, they should only point to a point of contact, and that they should not consent to workplace entry. You should also make very clear what areas are private and what areas are employees only, because with an immigration warrant, they can go into any public area. So to make sure to identify what is a private area, it's helpful to have signs that designate what's private and what is not. And you can conduct practice drills to ensure that this doesn't occur, or that people are following the process. So what do you do if ICE shows up? Well, the most obvious thing is to remain calm and professional. If you have a reception desk, if it's at a workplace with a reception desk or a front desk, that the person at the desk should notify the designated point of contact immediately. Like I said, ICE agents can be in public areas. If they are there without a warrant and they start giving employees or customers problems or interfering with business, the company representative can ask the agents to leave, just like they could ask anyone else to leave. So, when ICE arrives, what do you do? Continued. Okay. The point of contact should request identification from the ICE agents. So it's not enough to have someone show up and say, I'm an ICE agent. And in fact, if you've watched the recent news, there has been an arrest of an actual undocumented worker who was claiming to be an ICE agent, who was entering businesses and claiming that he had authority to do audits and raids. And he's just recently, I think within the last day or two, been arrested for falsely claiming to be an ICE agent. So you need to request identification from anyone. And if they are a legitimate ICE agent, they will provide identification. They know to do it. And so you should ask them to do it. So what else should the point of contact do? Well, they should ask for the purpose of the visit and whether there's a warrant. And And that, of course, matters, because if there's no warrant, then you don't have to allow the entry of the ICE agent. The other thing you need to do is contact your legal counsel immediately. And then let the ICE agents know that the attorney's been called. Doesn't necessarily mean if they have a warrant. For instance, if they have a judicial warrant, they're not going to stop doing anything just because the attorney's been called. But letting the ICE agents know that there is an attorney who is involved will help with the situation. And if you're presented with a warrant, make sure that you review it very carefully. Make sure you understand what it is. It could be an administrative warrant. If it is, then they're only allowed into public spaces to try to seize a person. If it's a judicial warrant, you need to identify what exactly can be searched and who exactly can be arrested. A judicial warrant will have limitations. It may say you can the ICE can search for evidence of illegal importation of sex slaves, for instance, including documents and videotapes and those sorts of things. And if it does that, that means that essentially anywhere you could put a document or videotape in a non-public area is searchable. However, as an extreme example, if it says, well, you need to find, you need to search for any vehicles used for potential importation of illegal immigrants, then they're not going to be able to search inside of drawers. They're only going to be able to search in areas where you could hide a vehicle. So it's important to closely inspect the judicial warrant. And you should actually ask for a copy of the warrant. They're supposed to give it to you anyway. And if you get it, then you give that copy to the attorney. Additionally, you should have the point of contact say, well, we don't consent to the search, but that they will comply. This doesn't mean you're trying to interfere. You comply, but the reason why you say you don't consent, or the person says we don't consent, means that if you give consent, then there's no warrant that's necessary anyway. So if an employee says, oh yeah, you can come look at anything you want to, what you've just done is, what that person has just done is eliminated the need for the warrant in the first place, and may have broadened the scope of the warrant to any place that the consent allowed. So you need to make sure that the point of contact says, well, we don't consent to the search, but that the point of contact does not interfere with the search, but that they just don't consent. Okay, so what happens during the raid? What should you do during the raid? Okay. Well, you assign that same point of contact to a company or another responsible person to accompany each ICE agent. Take notes and record the search. Don't interfere, though. Tell them not to interfere. You just take notes as to where they looked, document anything that was taken, and request copies of any documents that are taken. And if an agent attempts to seize business critical equipment like laptops or phones, ask them if or request them to provide to image those things instead of confiscate those things if it's possible. The other thing is that during the raid, you should ensure that the agents comply with the warrant's terms. So if the agents exceed their authority, object. Hey, you're only supposed to be looking for vehicles. Why are you looking in the drawer? There's not going to be any vehicles. And also have them document. And also, locked areas covered by the warrant should be unlocked if asked. Otherwise, they're just going to break down the door, or they're going to break open the drawer. So if they ask you to unlock it, then an employee should unlock it if it is covered by the warrant. Also, you need to let your employees know that they should remain calm and not run away. Now, fleeing from or running away from an officer or avoiding an officer is not essentially probably probable cause in most circumstances. But if combined with other things, somebody runs away, that could trigger an arrest. So you just want to make sure that you tell people, hey, don't run away. And this is not something that's just sort of out there. I mean, I represented an executive who was a highly compensated person at an employer. And he reported to me, it had nothing to do with immigration, but ICE showed up one day. His employer had a habit of employing people who were not documented. And I showed up, and he said it was like, there were 20 people trying to run out the doors to avoid getting arrested. And of course, all the doors were covered, and it caused quite a stir. And those people fleeing were illegal and all got arrested. All right. So then, also, employers may, but they're not required to tell the employees about their rights. You don't have to answer ICE's question. You can tell them that they don't have to answer ICE's questions. They don't have to hand over their IDs or papers. They have the right to the Fifth Amendment privileges. They don't have to disclose their schedules or locations. Employers don't have to. And they don't have to escort ICE agents to specific employees named in the warrant. So even if somebody has come and they've got a warrant to arrest John Smith again, if the ICE agent says, hey, take us to him, an employer does not have to take the person to them. It should not hide them. It should not do anything to allow the person to assist the person in escaping. But they don't have to take him to him. You can say, well, we saw him here today. He was, he was in the work area or in the garage, but you can go find him. You don't have to escort him to them. But whatever you do, don't lie. Don't give misinformation, and don't do anything to hinder the enforcement, to physically try to stop it, or to hide employees, or to hide documents that are relevant to a search. So what do you do after a raid? Well, if an employee is being detained, ask where they're being taken and let their families know. Request an inventory log of seized items. Preserve any company surveillance footage of the raid. So if you have surveillance cameras, make sure you save it. Document the event. Gather up all of the notes of everyone who had been accompanying those who were issuing, or who were accompanying those with the warrants, and identify the number of the ICE agents that were there, whether they were armed or not, names and badge numbers, and any potential mistreatment of anyone. And again, if the employees are unionized, notify the union. Okay, so perhaps the most important thing, what you don't do. First, don't allow ICE into private areas without a judicial warrant. Do not allow ICE access based on an administrative warrant into private areas. You can also resist, if you want, access based on the administrative warrant and require them to go and get a judicial determination of the administrative warrant before enforcing the warrant. You can do that. If the warrant is justified, that the court is likely to issue the warrant, but at least it gives you time. District court is likely to issue a warrant enforcing or an order enforcing the administrative warrant. But if you need time to prepare or to do other things, that at least gives you more time. Do not provide false information, destroy evidence, or help employees avoid ICE. Don't interfere with ICE's questioning of employees. They're entitled to question them. Don't disclose employee immigration status, national origin, or other personal details without the consent of the employees. That doesn't mean you don't provide, if pursuant to the warrant, an officer is entitled to look at your I-9s, that you don't provide the I-9s. What it means is you don't just volunteer the information upon questioning. Don't retaliate against employees for cooperating with ICE or for even being questioned by ICE. And don't allow employer representatives to give statements without consulting an attorney. So here are some additional things to consider. ICE is not the only agency that may conduct workplace enforcement actions. Department of Labor, some jurisdictions, state and local law enforcement can investigate businesses for immigration related or labor law violations. And the interesting thing to remember is that let's say you have a Department of Labor investigator show up at your business because they're interested in there's some claim that you're not paying a minimum wage. And so they've come to do an audit on your wage payment. They're looking through payroll records, and they're also looking at whether an employee is exempt. As they look through, all employment agencies, federal employment agencies, are required to report to other federal agencies if they see violations that are outside of the scope of their jurisdiction. So what can happen is if the Department of Labor is coming to look at your payroll records, and as they're doing so, they look through, you happen to keep your I-9s with the personnel records. They see the I-9s don't seem to comply. They are required to report to ICE that those don't appear to comply. And so you increase the risk that you might be doing an audit. Might be subject to an audit. So we always advise our clients to keep their immigration files separate from other personnel files. All of your I-9 files, all of the records of your doing E-Verify, all of those should be kept separately in a separate place from other personnel files, so you don't run the risk either of triggering ICE telling Department of Labor that they saw a violation of payroll, or that the Department of Labor then reports that there is an immigration law violation. So our recommendation has always been to keep those separate from each other. And I would do that as soon as possible, particularly given the likelihood, the increased likelihood that you're going to have an audit or a raid given the change in administration, and particularly if you're in the areas of focus of the administration. So that's essentially our presentation today. Just a reminder, our employment group includes me, Carolyn Howe, and Anna Briner. We're happy to help you with any employment issues that you have. And we're happy to respond to any questions that you might have that arose from this presentation. And we didn't get any questions while we were presenting, but if you have any now, it might be good to put that question into the comment section and we can try and give you an answer. We'll give you a couple of minutes to do that while James also, talks about some other services that the firm provides.
Thank you. Yes, really quickly, we wanted to mention that we work with Assurance Lien Services to provide several services related to filing liens. In order to record a construction lien in Utah, you must do an SCR filing first, and that's either a preliminary notice or notice of commencement. You have a right to get paid for the work that you do, so it's important that you do these SCR filings when you provide materials or provide a construction service. We have clients that we perform SCR filings for in bulk and do it at a discounted rate. But for for filing these preliminary notices and notices of commencements, if you're having difficulty locating something, that is something that we with Assurance Lien Services specialize in, finding tricky parcels to do these SCR filings. And then, of course, if you do have to lien something, we perform that and we do it at a flat rate, and also these lien releases. If you have questions, you can email us at liens@crooklegal.com, and Assurance Lien Services website is lienservice.com. Just wanted to mention that briefly at the end of the presentation, since a lot of the people who will be viewing this are in the construction industry. And that concludes our presentation. Scott, is there anything you wanted to add to the end there?
I just want to mention too, although I didn't give this disclaimer at the beginning, obviously, what we've discussed today is a general discussion of the law. If you need specific advice, you need to talk to a lawyer. We're happy to do that for you, to talk to you about that. But if you need particular advice about a specific situation, make sure you contact a lawyer. Thanks. It's been great doing this presentation. We're happy to, if you do have any additional questions and you want to talk to us offline, we're happy to have you reach out to us. Our website is crooklegal.com, and my email address is scott@crooklegal.com. Anna's is anna@crooklegal.com, and Carolyn's is carolyn@crooklegal.com. So if you have any question, feel free to call us, and also you can call us at our firm at 801-839-7905, and we will try and get you an answer as soon as possible.
Okay, thank you. And very last thing, to those who registered, we will distribute these slides soon to you. If you did not register, again, go to crooklegal.com. You can contact us through our contact form or reach out to Scott or Anna or Carolyn or me, and we will get you this information. So thank you. We'll see you again soon.